Welcome back to Law Ministry Update. I'm your host, Charles Hedman. I work here at Brotherhood Mutual as in-house counsel. Today's episode is about property issues that churches and ministries and schools run into. We've got a great guest here today to talk about that. Dan Dalton is with us. Dan, thanks for joining us.
Good morning. It's great to be here.
Dan, explain a little bit about yourself, your background.
Sure. I'm an attorney out of Detroit, Michigan. We represent ministries throughout the United States, primarily in property disputes, whether it's local churches who want to build and zoning is used to keep them out, or if a local church wants to leave a denomination and keep their property, we help the local church. In some cases, we help denominations. And we also help churches merge when there's two ministries that feel like joining together would be a good thing for them. We help them as well.
That's great. That's great. And Dan, I've seen your work. It's tremendous stuff. I know we've used it here at Brotherhood Mutual. I want to start off our conversation today with the last thing you mentioned there, church mergers. Is it me or is it true that church mergers are happening more frequently nowadays? And if so, what would be the cause of that?
A lot of it is transitions of pastors, where a pastor's ready to retire. They don't have a number two. There's not a lot of pastors in the pipeline within a denomination, or they've tried recruiting pastors from other churches and it just hasn't worked out. So you have a thriving church, older congregation, debt-free building, and then you have no one to really fall into place. And they identify another church that might be located in a school or a theater with a younger pastor, a younger congregation that is looking for a place to go. And those are the best type of mergers where you have like-minded people that want to grow a ministry. And those are the ones where you see the mergers work the best. So yes, we are seeing more of those as well.
I know the pastoring in general is getting older in terms of their ages of pastors. Question for you: are all church mergers the same? Are there different types of mergers? Help us understand that.
Sure, there's really three different types of mergers. That the first is the mergers where you have two weak churches, two churches where not much of a membership that is left, older pastoral staff, older elders or trustees, and they believe that if we merge together, we'll thrive. And quite frankly, those don't work. Where you have two failing ministries, quite frankly. The second type of merger is the merger where you have a young church without a property in an older church where there's just, again, not a lot of members, but the older folks want to maintain control over the ministry. So they want new people to come in, but they want to maintain control. Those are difficult mergers as well because it's usually the younger church, the younger members is going to grow the church, and the older people are resistant to it. And again, those are difficult ones. But the third one is the one that we just talked about a little earlier, which is where you really have people working hand in hand together.
It's incredible to see when two ministries who are like-minded can join together and resuscitate both of their ministries going forward in something that's coherent.
It takes a lot of humility. It takes people to step back and say, this might not be the right place for me right now. It takes people, leaders, to say, I'm going to give up control and give up power, give up thoughts in terms of how I'm going to run this ministry. It takes a lot, especially for that older church that has been around for so long and has been so established, to say, this just isn't working anymore. We need somebody else to come in and do this for us.
That's wonderful. What are some common pitfalls that occur when a church starts to think about a church merger with another institution?
If they think about it as a merger of equals, that's the biggest pitfall. Somebody has to leave, and somebody's going to have to go away, unfortunately. So you have to have those discussions at the outset of, how are we going to run this organization? You should come up with like a term sheet of who's going to lead. What is the elder board going to look like? What is our theology going to be? Really important topic. After that is who's going to stay and who's going to go in terms of staff, because there's going to be duplicate staff. How are we going to, what is the vision we're going to have for this organization moving forward? And you have to have clarity and unity on that vision as well. And once you have all those things to come together, it works. If you come into it thinking like we're going to merge, we're going to be equal, we're going to have equal power and sharing and services, and we'll have one pastor on, the first and third Sunday and another on second and fourth, it's just not going to work because you're going to have different visions and different understandings and, different um, outcomes.
So, in terms of the legal side, the documentation side, if I'm a church and I'm looking at either, look, I have to close my doors or I need to merge with another church, and I've got that opportunity. And let's say I've got 60 days to decide. which route I want to go. What are some things I need to do from a legal perspective to think through accurately what my procedures would be?
You're gonna wanna look at, um, how you're to structure the merger. So if you're looking to, you're going to be the acquirer or you're going to be merged into, like which party you're going to be. If you're going to be the acquiring party, you're going to want to look at the debts and liabilities of the other church. So, are there any claims outstanding or potential claims? Are there any mortgages, debts, other types of liabilities that we need to think about? Are there potential claims? Let's think through all those particular issues. You're also going to want to look at, as an acquirer, you're going to want to look at what state you're in to see, what are our potential outcomes. So, for example, in Florida, there's an unlimited statute of limitations for abuse claims. So that one, you're probably going to want to do a acquisition as opposed to a merger to kind of cut off any type of liability for the new entity. If you're being the church merged into the new entity, what you're going to want to think about is what is my role in this next step? Do my leaders become part of their leadership team? Do I have a role in this leadership team, or do I transition out to another ministry? What happens to the physical assets? For example, do I need to talk to people about donations they made for like a windows or some sculptures or something within the building? Do we have to get those donations in? Do we have money held in reserve, like a trust or an endowment? What do we do with those funds as well? You basically want to do an outline of what is it that we own, and what are things that we will keep, and what are things that we have to kind of address in the future. What are our liabilities and things along those lines? After that's step one. Step two is do we have the buy-in? Do we have the leadership buy-in, and do we have the congregational buy-in? You're not going to get everybody to agree. You want to get the majority people, the 20% of the people that kind of come to church and donate and do everything at the church. Those are the folks that you want the buy-in for, and you want to talk to them immediately about, hey, this is what we're thinking about doing. What do you think about that? Let them make the decision, get the buy-in. After you get that, then you go to the small groups, you go to your congregation and say, this is what we're planning on doing. You know, according to your bylaws, you might have the congregational vote, or it might just be the bylaws require the leadership to vote. But you want to have the congregational buy-in because you don't want to merge and then everybody leave. And so take care of that first step of what is everything that we own? What are our outcomes for those things? Second thing is look to your buy-in.
That's good. You mentioned mergers versus an acquisition. What's the legal difference there, and why would I choose one versus the other?
So it depends on what your state you're in. So kind of going back to Florida, we're working on one right now, so that's what's top of mind there. In Florida, for example, you have claims that might arise after the transaction occurs. So when you merge, you become one entity. You're taking all the assets and liabilities into this new entity.
So you're accepting the liability from this other entity into your own.
Exactly. That might not be the best way to do it. Now, politically, that might be the only way to do it because if you're doing an acquisition, the party being acquired might not think like, well, if I wanted to join that church, I would have joined, the church. I don't want to be acquired into this kind of thing. So you might need to say the word merger or something like that, or think through that whole idea. But in some states where you have these trailing liabilities that could be out there, you probably do want to do an asset purchase, which is we're going to buy your building, we're going to buy your preschool, we're going to buy your all your other assets that you have out there, and then anything else that remains, we're going to have to leave out.
Hmm.
So that could be a good thing from a liability standpoint. When you do that, though, what you kind of have to realize is that you're giving up uh, other assets that could come in the future. Thinking about like wills and trusts. So if somebody makes a gift to the church being acquired, that entity no longer exists anymore. So the entity that is acquiring is not going to get that asset. So if like a large gift is coming in, you might want to do a merger as opposed to an acquisition. But again, it really depends on the state that you're in.
That's very interesting. Can you buy the name? Can you acquire that name?
You can acquire the name, and you could keep that entity alive, but then, it's gonna give up some, issues for, lawyers, for example, that might say this really wasn't an asset purchase. This is a merger. You kept, you wanted the benefit of it, but, because of that, you also get this liability of this claim that was out there 50 years ago or whatever whatever the time frame was.
Yeah, very interesting. One of the big issues that I've seen occur when a church merger is discussed, and actually outside that realm as well, is the issue of trust clauses. So when I'm leaving the denomination, if I'm trying to merge with another church, there's a trust clause issue that I don't think many churches are aware of, particularly if they're in a hierarchical denomination. So let's say I'm a church and I'm merging with another church. We've identified that we are very close in our theology, that we think we're going to work really well together. But then we want to somehow create a documentation that allows us to operate as a merged church. Say in the bylaws or our governing documents, what are some things I specifically need to have in those governing documents that's going to disallow me from running into hurdles down the road?
Sure, you wanna and it's a great point because you wanna have that set up before the merger, occurs. The first one is how many people are gonna serve on the board? What's their terms? And it's the initial board member, that how that initial board is gonna be constituted. That's really important. It's really important about, uh, how the board is gonna act. In other words, is it going to be a board that's gonna be a working board? Meaning they're actually gonna run the church, or is it gonna be a more of an advisory board where an executive team that comes to the, board for specific strategic matters? So if you're a older, larger church, you're probably gonna wanna have the latter of the 2. The strategic part of the board's function is like a typical board of, we're gonna tell you, we're gonna hire the pastor, but the senior pastor is gonna hire all the other staff. The senior pastor is going to decide the color of the carpet in the sanctuary. We're not going to decide that on a board level. We're going to talk about this ministry should do something in the future. Like we should support missions in Cuba or whatever the case may be. And we're going to cast that vision. Pastor, you implement that. You pastor comes to us with different ideas. We think this is a great idea, or this is something maybe we should hold on for a little bit. Um, if you're gonna be more of a working board, you're gonna wanna think about how your staffing is gonna work, because staff is usually gonna kinda be resistant to that and chafe against those things. But you might wanna structure this in a way of like, we're gonna be a working board until we get this thing stabilized or worked out. So sometimes when you have an older congregation, younger congregation coming together, there's gonna be friction between the 2. So you might wanna have that, set up so it's just an advisory type of role as opposed to a working board. If it's 2 older boards coming together, they're not gonna give up that power, they just won't. So you're gonna have a working board, but also ratcheting down over time, to be more of a functioning, advisory type of board. So you just wanna kinda structure that board to the culture of the church and make sure that you're all, on the same point and the same level in terms of who's making decisions, how the decision is gonna be made, and then kinda going from there.
What is a trust clause? I know you're an expert in this.
Sure. So a trust clause is a affirmation by a denomination that says, we have a future interest in your property when we decide. Kind of think about it that broadly that way. Um, Trust clauses are generally they were formed by John Wesley, who was an Anglican priest, formed the Methodist denomination years ago. And the whole purpose originally for the trust clause was there was meeting houses in England, and he wanted to make sure that if a pastor left, that the Methodist faith, he was still Anglican, but the faith that he was preaching at the time would continue on with a different pastor, but in that meeting house. And that concept came to the United States. And a trust clause basically is local church, you own your property. If you look at the title of your deed, it's going to say, ABC Church. It's also going to say held in trust pursuant to for example, the Methodist world, the Book of Discipline, under trust provision, and we at some point in time can certify this trust when we choose. And so that's basically again, it's a future interest. If it's not, they don't own it. You can get your mortgage, you can do whatever you want with your property, but it's just something that we can cling to in the future if we want to take your property.
Hmm.
And it's in the Episcopal Church has it. It's called the Dennis Canon. In the Presbyterian Church USA has it. It's in their Book of Order. The Christian Missionary Alliance have it. A number of denominations have it right in their particular denominational rule books.
Interesting. So, are these trust clauses that effectively say, "Hey, the denomination gets the property if this church would leave the denomination," are they enforceable, and are they enforceable in all states, or does it depend?
Yeah, it really depends. There's two types of trust. There's express trust and applied trust. An express trust is something in the articles of incorporation or in the property deeds that say this property is held in trust for the, you know, blank annual conference of the United Methodist Church, for example, or the presbytery of, whatever plains, whatever
And that's in the specific church documents
that's in the
themselves.
church documents themselves. And, and so in those cases, it depends again on what state you are. That will be evidence that you are agreed to be your property being held in trust. So if you're in Florida, you're in Georgia, um, Maryland, Wisconsin, Washington, California, probably going to be enforceable there. Some states like Maryland, Washington, and Wisconsin actually have statutes that say that we are going to enforce the trust clause of this denomination. An implied trust, on the other hand, is where you don't have that language in your deeds or in your articles of incorporation. But it's an argument of the denomination that says, because you are part of the United Methodist Church and you've agreed to our doctrine and discipline, you agree that your property is held in trust. And again, that's going to be it's state by state decision. So if you're in Texas, it's not going to be enforceable. Ohio, Illinois, it's not going to be enforceable as well. Most states have looked at these issues, some have not. So really it's state by state specific. You just kind of have to kind of take a look at the state law on this. The thing you're going to look for is what's called neutral principles of law and or hierarchical deference. If it's hierarchical deference, it means that the denomination wins. If you have a religious property dispute, it goes to the hierarchy, and they're going to decide. They win. So that's Georgia, Florida. If it's neutral principles of law, they're going to look at our trust law, our corporate law, our property laws within a state to make that particular decision.
Hmm.
And then there's a hybrid, like in Tennessee, for example, has a hybrid neutral principles that says we're going to look at these things, but we're also going to defer to hierarchy as well. So state specific on those particular issues.
I'm curious. So let's say I'm a church leader, and I am considering leaving the denomination, but I'm aware that there is a trust clause. That trust clause very well may apply in my state. What are some things to think through as I'm considering leaving the denomination? Things I should be aware of, things that maybe pastors don't think about as they're having this conversation with their leadership.
The number one thing I would think about is um, what is the value of this building to this congregation? In most church families, the building itself has a very high value to it because families have been there, generations have been married there and baptized, confirmed, funerals. Families have donated, altars, narthexes, artwork, all sorts of things. The memories is what the value is. There might be a cemetery out back as well where family members are buried. Think about, is it really worth staying and having this fight for this building? Is the congregation really want to have that fight, or do we need to have that fight? And that is a hard conversation to have because you love the building. You've been there for a long time. You've formed friendships there, and your family's grown up there, and the whole nine yards. So a lot of times that answer is going to be yes. The second thing is maybe objectively have somebody give us a true value of this building.
Yeah.
You know, maybe it might be the value of the land and the building itself might be good, but if the condition of the building's not great, If a building's worth $1 million, for example, $1 million, and you might have to put in 3 million to be it, bring it up to code or to make it more family friendly or more friendly to how we do ministry today. It might be cheaper to go buy a piece of land somewhere else, or another building somewhere else, rent for a little while somewhere, and do that. Um, so look at the economics as well. Look at the buy-in, from your congregation. Would they do they want to go through this fight? A lot of people believe that there shouldn't be a lawsuit between local churches and denominations. They shouldn't sue each other, and that will have a significant impact on that church and on that denomination. Um, Look at also the emotional cost.
Hmm.
These are hard cases. They're unpredictable. They're extraordinarily expensive. The local churches, it's any type of litigation. You're gonna have wins and you're gonna have losses. You just have to expect that going through that. And how committed is your leadership team to this whole thing? Don't leave it to the pastor. The pastor's got to preach, not only preaching on Sunday, but it's got to marry, it's got to bury, it's got to counsel, it's got to baptize, it's got to uh, teach during the week. Pastors are. It's one of the hardest jobs I think that's out there, and there's so many other things pastors to do. Don't make this a stress of the pastor. Have a leader that is committed to this, and a group of leaders that they can talk to each other about what to do strategy wise to move forward in this manner. And once they commit to it, everybody commits to it to the end, not to like, we're going to commit this for 6 months and see how it goes. Make sure that you're absolutely committed to it. If you're a denomination, you might want to look at is, you know, what's the value of this property? If is the juice worth the squeeze, as they say?
Yeah.
If this is a property in a remote part of the town or a state, it's not going to sell. You're just not going to get your money out of it. So is it really worthwhile having this fight over this property? And some people here in Indiana, for example, we just finished up one in the southern part of the state where it's a small town, and but the denomination fought tooth and nail on this particular matter because they wanted to set the principle like you cannot get out of this denomination. So we had to file a lawsuit and go through the process to do that for them. We have other cases where we represent denominations, and the local church had a rogue pastor, and a whole bunch of things went wrong there from the denomination's perspective, from the local church, what they did from a governance perspective. So they had to enforce their trust clause there to preserve the property for people who have left that local church because of what they saw what was going on there. So it really you have to kind of factor all that together. But there's a financial cost and there's an emotional cost that a lot of people don't think about when they start this. They kind of think about, we just want to leave the denomination, or we want to pursue this particular property on behalf of a denomination. That's just one of the factors. Think about everything else that goes into it.
So good. So good. And those are things that I know I wouldn't have thought through before having conversations with you a couple of years ago. I want to switch subjects a little bit now to zoning issues. So let's say my church, I'm a ministry, I'm growing, I want to expand the use of my facilities. So I'm going to either buy new property elsewhere or expand the property that I already have. What are some things to think about as a ministry leader as I'm thinking about expansion or using my facilities in a different way?
Look at the zoning. It's so important. I can't tell you how many times we get calls from ministry leaders and pastors that got a great deal on a piece of property. It's in a perfect location. It would be great for a church. They bought it at a distressed sale or foreclosure, and they learned they can't use it for a religious assembly
Does that happen often?
all the time.
Wow.
Same thing with location and parking, which are the big issues, and easy to convert buildings. Walmart, when they went from 80,000 square foot buildings to 120,000 square foot buildings, um, they sold a lot of their properties, but they have deed restrictions. So you can use the building for anything that doesn't compete with Walmart, which is a church. That's about it. So, you have those properties where cities are used to 30, 40, 50 years of, 5 acres of commercially zoned land that has been generating all sorts of property taxes. They have a church come in and they're like, no way, we're not going to allow you to be here. So a lot of times people buy properties, they get a great deal on it, and they don't check the zoning. or their commercial realtor will say, "Don't worry about it. I'm sure it'll be rezoned. Sure, it won't be a problem." And it turns into a big problem. So check your zoning, check your zoning, check your zoning. That's the number one thing they need to do. And it's easy to do. You just contact the city, and there's usually an online form or something that you can submit. And you can challenge zoning codes, and that's a lot of what we do as well. Where there is in a city, for example, that doesn't have any place for a church to be approved as a right. It all has to be conditional use, or the conditional uses are like next to a nuclear waste dump, or something like that, where nobody wants to be, so we can challenge those. Or if you have a zoning district where, you allow secular assembly, but you don't allow religious assembly. So you have theaters, you have city halls, parks, funeral homes, libraries, places where people assemble, from a secular position, generally speaking, under federal law, you can get that approved as a religious use, but you have to go through litigation to do that.
So you mentioned there being potential federal protections. What are those federal protections for religious organizations to use this land as they so want to?
Sure. So there's a federal law called the Religious Land Use and Institutionalized Protection Act, or Persons Act. It's RLUIPA is the acronym, and that's the main one. And what RLUIPA does is essentially puts religious institutions on a level playing field with secular assembly uses. So kind of think about, like, if you allow that secular assembly use, like a theater, you have to allow the religious assembly use as well. There's other provisions in RLUIPA that what I talked about is the equal terms provision. There's substantial burden, which is the other main one, which is if you apply your zoning designation to a local church, and it doesn't, and you don't allow that use to be in this particular zoning designation, and for a variety of other reasons, the church can't be in a local town anywhere else or whatever, you can have a substantial burden type of claim. You just prove a substantial burden is a term of art, a constitutional term of art, meaning that depending on what circuit you're in, it's basically that you can't perform your religious activity on that particular property. The burden then switches to the government to show a compelling governmental interest in denying the use, and that compelling governmental interest is the least restrictive means of doing so. So other than completely barring it, there's something else that can be done. So RLUIPA really does play a large role in helping ministries, Christian, any type of religious ministry in your local community.
That's good. Are there state laws that are like Arlupa that do effectively the same thing?
There are state laws. There's state they're called RFRAs, Religious Freedom Restoration Acts, that try to do the same thing. Unfortunately, a lot of states don't have they have the law, but there's no enforcement mechanism. There's no remedy. So you can prove a RFRA violation, but there's nothing for a judge to do to issue an injunction or get money damages or attorney fees to allow that ministry to move forward. So, like in Missouri, for example, has one, but there's no teeth to it. There's no, so you won. Okay,
Now
that's
what?
it. So I don't rely on the state RFRAs too much for those matters. It's mostly the RLUIPA, and you can also rely on the First Amendment free exercise clause as well. There's since about 2022, the United States Supreme Court has interpreted the free exercise clause more broadly, that affects and helps ministries in this particular issue.
So let's say I'm a ministry and I'm running into zoning issues. I'm running into what I feel are unfair zoning issues with the commission. What are my steps? What do I need to do to kind of pursue this? Because I really want this land. I really want to use it in a particular way, but I'm running into challenges, and we hear a lot about those.
Sure. So there's two things you need to do. One is it typically, generally speaking, you have to exhaust your administrative remedies, meaning that you have to get the no from the planning commission. So you may be told by the planning department you're not going to get this. And the whole idea is to discourage you from moving forward. But you have to actually apply, go to the planning commission, get your no. That's when it's called exhaust your administrative remedies to move forward.
So I can't just say, "Hey, Melody told me over the phone this isn't going to happen. I've got to have an actual no in writing.
You gotta get a no, yeah. Because in a lot of circuits, like here in the 7th Circuit, in Indiana, you have to get that no to go forward. The 9th Circuit in California, is a very, uh, clear and definitive no as well. The exception to that, though, which is the second part, is maybe the ordinance itself violates RLUIPA. It's called a facial claim. So on its face, that the ordinance discriminates against churches. So if a zoning code says you could have no churches in the city of Fort Wayne, Indiana, for example, or whatever city you're in, that would violate RLUIPA. There's an exclusions claim. Or if it says we're going to interpret this to make sure that you can have a church, but it can only be 10 square feet, and it has to be 6,000 foot setback, and it has to have parking for 4,000 people and all that kind of stuff. That's an unreasonable limitation under RLUIPA. Or if there's a number of different things that could happen that they could interpret it in a way that would violate federal law or the free exercise clause as
Oh,
well.
that's interesting. Where do you see zoning issues come up most frequently?
Right now, it's recovery centers. So a lot of churches have rescue missions or missions where helping homeless or and helping people coming out of addiction. A lot of times, when people will go to a hospital, they're in DTs, they come out of addiction, and if they're pushed back to that environment they came from, they're going to fall right back into that addiction trap. So there's places that you can go, and a lot of ministries are creating places for longer term treatment and care. In Albany, for example, there's the Capital City Rescue Mission. It's been around for a very long time, and people stay there up to 2 years to learn life skills. I mean, a lot of these folks need to know, how do I work, how do I dress, how do I live on my own to break the cycle of addiction.
Kind of wrapping up things, we've spoken about church mergers. We've spoken about trust clauses and zoning. Are there things in which you would just some pointers you would give the churches as they're thinking about property issues that we haven't touched on that you see quite often that would be helpful for these ministry leaders to know?
When you're thinking through these issues, think about all the potential impacts. And a good resource is insurance. Talk to your insurance carrier, your broker about these are the things we're thinking about. What do we need to know from an insurance perspective or a risk perspective that we need to cover when we're thinking and planning through these particular issues? Thinking about your congregation itself. Do we have buy-in for these issues? Change is hard. We all understand that. And congregations kind of fall into complacency a lot of times, and we're comfortable doing these things. Do we have that buy-in to make those merger, plans, or building a new building plans, or, um, y- you know, leaving a denomination or joining a denomination? Kind of think about those buy-in issues. Leadership has to be on board. Leadership needs to kind of get that training and that understanding of these are all the bigger, broader issues that we need to think about for casting a vision for this particular ministry to move forward, whatever that ministry may be. Our church, for example, we have a food pantry. We serve about 250 to 300 families a month where they come in and they get a trunk load of food, and we've committed to that, and we continue to do that because we think it's the right thing to do. And we help our broader community, not adjacent, but more broader community, with that. So that might work for one church and it might not work for another church because we have the buy-in in our particular congregation. So think through all of those particular issues, have a plan, have a vision, talk to your professionals in those issues when you're thinking through those issues.
That's really good. Dan, this has been fantastic. Thank you for the guidance that you've given. If a church or a ministry anywhere in the country has questions about, hey, do we have a trust clause? How does that work? Or a church merger, or we have a property issue, is there a way to get in contact with you?
Sure. You can go to our website, Dalton Tomich, DaltonTomich.com. You can find me on LinkedIn, Dan Dalton on LinkedIn. Um, those are probably the two primary places.
Well, I just appreciate your heart for the church, brother. It's I'm getting to know you a little bit. It's tremendous in the way that you intentionally seek out. It's amazing that a believer can help other believers in these very tricky capacities from a legal perspective. And so we're just very grateful for you.
I appreciate it. Thank you. It's great to work with you as well.
Thank you all for joining us for another edition of Law and Ministry Update. We hope you join us next time.